Appeals 1825 to 1862, Volume 1. 1st December 1836. Present Lord Brougham, the Vice Chancellor, Sir L. Shadwell, Mr. Justice Bosanquet, the Chief Judge of the Court of Bankruptcy, and Sir John Alexander Johnston. An appeal from the Court of Sadar Diwani Adalat of Bombay. Sorabji Vachaganda, appellant, versus Kunwarji Manikji, respondent. K brought a suit against M&S, alleging that they had dealings with him, that their account current was regularly adjusted by their gumastas up to 1860, and that on the 9th Pus Sood 1862, there was a balance in K's favor of rupees 7,132 rupees, 1 annas 60 paise, which with interest amounted to 13,689 rupees and 75 paise. In support of his case, K produced his own books of account, and there was no evidence to show that the defendants who denied all liability and were privy to could be bound by those accounts. Held that decrees founded thereon must be reversed. The Vice Chancellor. On the 6th April 1813, Kunwarji Manikji, the respondent in this appeal, brought his plaint in the Zilla Court of Surat against Munji Bhai and the respondent Sorabji, alleging that they had dealings with him, that their account current was regularly adjusted by their gomastas up to 1860, and that on the 9th Pus Sood 1862, there was a balance in the respondent's favor of rupees 7,132 and annas 1 and paise 60. This claim against the defendants was for that sum, principal and interest equal in the whole to rupees 13,689.75 paise, from which he deducted rupees 2,125 principal and rupees 2,070 rupees 3 annas and 6 paise as interest, making rupees 4,195 annas 3 paise 6 on the acceptance of Harmasji Bhinji, who, it was alleged, had not paid the plaintiff area, leaving a balance against the defendants of rupees 9,493 annas 19 paise 69. The defendants answered separately. The appellant denied having settled accounts with the plaintiff's gumasta. In support of his case, the respondent produced an extract from his own accounts. 2 letters were also put in evidence and some witnesses were examined. The inference from the letters just a minute. Rather was that there had been separate transactions between the respondent and the appellant, but there was no evidence to show that the appellant was privy to the respondent's account. The Zilla Court, however, on the 24th May 1815, decreed that the defendants should pay to the plaintiff the sum of rupees 7,132 annas 160 paise, the amount of the principal sum claimed according to the daftars of the plaintiff. but refused to decree interest thereon on account of the plaintiffs having laid by for 7 years without prosecuting his demand. The respondent, on the 17th October 1815, brought another plaint in the Zilla court against Manji Bhai and the appellant to recover the 2125 rupees and interest on account of the acceptance of Hormuzji, and on the 26th March 1817, the court decreed that the defendants should pay to the respondent the 2125 rupees and interest. The only evidence in that suit was that it appeared by the evidence of Hormuzji and the plaintiff's daftars in the former suit that the 2125 rupees had not been paid to the plaintiff. No additional evidence was offered to show that the defendants could be bound by the plaintiff's accounts. The respondent appealed to the provincial court against the decree of the 24th of May 1815 because interest had not been allowed him on the sum recovered, and the provincial court on the 10th November 1815 decreed the appellant and Manji Bhai to pay the interest which had been disallowed by the Zilla court and the costs of the appeal. The appellant appealed to the provincial court from the decree of the 24th of May 1815, but on the 23rd July 1816, the provincial court affirmed the decree. The appellant also appealed to the provincial court from the decree of the 26th March 1817, but on the 14th April 1818, the provincial court affirmed it. Upon three distinct appeals to the court of Sadar Divani Adalat, in two of which Sorabji was sole appellant, and in the third, he and Munji Bhai were joint applicants from the three decrees of the provincial court. Those decrees were affirmed with costs by these decrees, two of the 25th March 1818 and one of the 12th May 1819. The appellant, Sorabji, has presented his appeal to His Majesty in Council against those decrees of the Sadar Divani Adalat. It is observable that if the first decree of the Zilla Court were right, its second decree might be right also, for the claim for the sum of rupees 2125 and interest rested on the same ground as the claim by the first plaint. And if those decrees were right, the decree of the provincial court upon the appeal of Kunwarji Manikji for the interest disallowed by the Zilla court might be right also. But if the decree of the Zilla court upon the first plaint was wrong, then that plaint, as well as the plaint in the second court in the Zilla court and the appeal of Kunwarji Manikji to the provincial court, should have been dismissed with costs. No evidence was brought before the provincial court or the court of the Sadar Divani Adalat, which was not before the Zilla court, so that the decrees can only be supported by holding that one party producing his own books of account can bind the other. But such a proposition is utterly untenable, and the result is that all the 8 decrees of the Sadar Divani Adalat court are wrong. That the three decrees complained of must be reversed as to the appellant, but without costs, and the decrees of the provincial and Zilla courts be reversed so far as they direct the appellant Sorabji to pay principal, interest or costs. But the two original plaints in the Zilla court and the respondent's appeal to the provincial court must, as against the appellant Sorabji, be dismissed with costs. 1st December 1836. Present. Lord Brougham, the Vice Chancellor, Mr. Justice Bosanquet, the Chief Judge of the Court of Bankruptcy, and Sir Alexander Johnston. On appeal from the Supreme Court of Judicature at Fort William in Bengal. Janaki Das, appellant versus the King at the prosecution of Bindaban Das, respondent. One not residing at Calcutta was held to be amenable to the jurisdiction of the Supreme Court if he was privy to and preserved and cooperated in a misdemeanor committed in Calcutta. Mr. Justice Bosanquet. The appellant in this case, having been convicted upon an indictment for conspiring with others as Calcutta wrongfully to cause the prosecutor to be arrested and imprisoned without reasonable or probable cause, applied to the Supreme Court for a new trial, which was refused. But the court, pursuant to the 17th section of the Charter of the 26th March 1774, gave him leave to appeal from that refusal to His Majesty in Council. Upon the hearing of this appeal, 3 points were made. First, that the caption of the indictment was defective for want of stating that this indictment has been found by 12 jurors. Second, that as the appellant, a native of Benares, had never been in Calcutta and was actually resident at Benares when the offence was committed, he was not subject to the jurisdiction of the Supreme Court. And third, that the evidence given at the trial was insufficient to support the conviction, or at least that upon the weakness of that evidence and the affidavits adduced in contradiction to it, the appellant was entitled to a new trial. The first of these points is not a matter for consideration upon this occasion, which is an appeal from a refusal of the court below to grant a new trial. No motion in arrest of judgment was made in the Supreme Court and no judgment has been given. If the appellant should be called upon to receive judgment, he may, if advised, move to arrest the judgment and the court will deal with that motion as may be thought fit. The second point, respecting the jurisdiction of the court, is involved in the question whether the charge of the appellant having, in Calcutta, conspired with others for the purpose stated in the indictment was sufficiently proved. The offence with which the appellant is charged is a misdemeanor, and if he, though resident at Benares, was privy to and preserved and persevered and cooperated in a conspiracy with others who were in Calcutta to cause the prosecutor to be wrongfully arrested there, he was guilty of that misdemeanor and was chargeable with having committed it in Calcutta under the general jurisdiction of the Supreme Court over all persons who commit offences there. This very point was lately decided in this place upon an appeal from Bombay in the case of Punyakote Mudaliar, who was indicted for uttering a forged receipt in Bombay, which by the 53rd George III C 155 section 115 is made a misdemeanor. He was at the time when the offence was committed at a great distance from Bombay. Two questions were argued with respect to the jurisdiction. First, whether the defendant was subject to the general and local jurisdiction of the court, and second, if not, whether he was subject to the personal jurisdiction in respect of his service rendered to the East India Company. The second ground was not relied on by the Advocate General in the court below, who had professedly put the case upon the first ground, and the Judicial Committee thought it quite unnecessary to pronounce any judgment upon the second ground, being of opinion that the fact of the case established the point that the offence charged in the indictment was committed in Bombay. After examining the evidence at considerable length, the committee expressed their opinion that the jury were warranted in finding that Punyakoti was privy to the transactions and consequently was a participator in the misdemeanor. The question therefore arises whether, being a participator in this misdemeanor, he could be charged with having committed the offence in Bombay. Now it has been repeatedly decided that where a misdemeanor is is completed, the offence may be charged to have been committed. A variety of authorities may be found upon the subject. Several of them are cases when the jurisdictions within which the different parts of the transaction occurred were of totally different kinds, notwithstanding which the indictment has been supported in the place where the offence has been laid, such being the place in which the misdemeanor was completed. There are cases of nuisance, of libel, of fraud, of cheat, and of conspiracy. The authorities referred to were Hawkins, PC, Book 2, C25, Section 47, Rex versus Johnson, 7 East, 65, Rex versus Brissac 4 East 164, Rex versus Cumbes 1 East PC C5 S131, 1 Leech Crow Cas 432. Supposing, therefore, it was said to be of an ordinary person, whether a native of the provinces or a Portuguese or any other foreigner, and to have proved the offence to be committed, there is no doubt he would, on the authority of these, have been liable to be prosecuted for the statute misdemeanor completed in Bombay as a person subject to the general jurisdiction of the Recorder Court. It was further suggested, however, in that case, that the defendant was not subject at all to the jurisdiction of the court of the British government because he was resident out of the British limitations and within the dominions of the Nawab of Arcot, an independent prince. But whether he was or was not in the service of the East India Company, he was subject to the personal jurisdiction of the court, as it was said to be clear that he was employed in the care of the British forces, then engaged in the Diwani under the authority of the British governor, though in the dominions of a native prince. He was therefore under the protection of the British laws and consequently owed obedience to them, according to the well known maxim of the law, protectio trahil subjectionem and subjectio trahil protectionem, which means protection draws subjection and subjection draws protection, and having been guilty of an offence which was committed by his procurement within the local limit of Bombay, he was indictable there as much as if he had been personally within the limits of the law. As to the case present on that where Judge Johnson was held indictable in Middlesex, though he was never not of Ireland. In the present case, it is sufficient to say that the appellant was resident at Benares, which is in the British limitation in India, and was consequently liable to be indicted in the Supreme Court for an offence committed in Calcutta, in respect of which the British law subjects all offenders to be indicted there. The remaining question to be considered is whether satisfactory proof has been given of the appellant's participation in the offence. It appears by the evidence of the prosecutor Bindaban Das that in the month of August, which corresponds to Straban in the year 1828, the appellant was brought to Calcutta upon an attachment issued upon a cross bill against him, filed in the name of the appellant. That a person named Jagannath, one of the defendants, was the appellant's agent at Calcutta, and that he, together with other defendants then in Calcutta, conspired to procure Bindaban's imprisonment and detention by means of a fabricated document purporting to acknowledge a debt of 12,000 rupees due from Bindaban to one Ramchandar, another defendant who had absconded. The indictment was found in December 1828. In March or April following, 4 months before the trial, that is in the month of Chait 1829, Bindaban came from Benares on account of this indictment and did not return to Benares before the trial, which took place in August 1829. To prove the appellant's connection with this transaction in Calcutta, two witnesses were called. Mankaram Das, the eighth witness, who says that about the time of Bindaban's arrest, Janaki called to him from the window of his koti, and the witness then went upstairs where Janaki said, I hear you are going to Calcutta with Bindaban. I said, yes. He said, do not go. If you do go, you will be put to trouble for nothing. He is going from here in custody. Other complaints may then be made and he will not get his liberty. End of quote. That Janaki showed him a letter and said, quote, here is a letter informing me that when he gets to Calcutta, other complaints will be preferred against him. And Janaki said, I have also written to Calcutta directing that when he reaches, he shall not obtain his liberty. End of quote. Ganesh Bhatt, the seventh witness, says that he entered Bindaban service last Choit, which was March or April. Janaki called to him and said, "Your Babu is going to Calcutta. What is the use of his going? Let him take 20,000 rupees and give a Rafanama." End of quote. Bindaban was then coming for this case pending at the sessions about the 12,000 rupees. He says, quote, "Bindaban did give an answer, but the witness did not communicate it to Janaki." End of quote. If full credence be given to these two witnesses, their testimony certainly affords evidence from which the appellant's privity to some attempt to procure the respondent's detention at Calcutta and the desire to compromise the matter after the indictment had been found may be inferred. But it is to be observed that these witnesses speak to conversations only, obviously liable to be misinterpreted as well as misrepresented, and it was scarcely possible that the appellant could anticipate the testimony to be adduced against him so as to be prepared at the trial either to explain or contradict it by witnesses on his part. No evidence was adduced on the part of the prosecution of his having done any act to promote the success of the particular fraud attempted. On his part, he has, by his affidavit, not only denied all knowledge of the transaction, but all conversation with either of the witnesses and all acquaintance with them. And the great improbability of their account is corroborated by the affidavits of several persons. An application to set aside a verdict of conviction founded on affidavits made after the trial is always to be looked upon with very great jealousy. But when the evidence without contradiction is of so slight a nature as it is in this case, and the appellant could not be expected to offer evidence in opposition to it, for want of knowledge that it would be adduced against him, their lordships are of opinion that an opportunity ought to be afforded him of laying before a jury such evidence in his defence as he may be able to offer upon another trial. Lord Brougham. No observation arises except upon the conduct of the party or parties in respect of delay in this case. It is now towards the end of 1836, and the proceeding in question was 5 or 6 years ago. We have made particular inquiry as to the course to the proceedings took here in order to ascertain to what party this delay is imputable. It appears that the prosecutor never made any appearance at all. It was therefore necessary for the defendant, in order to force on the case after having lodged his appeal, to take the usual steps by summons, of which two are served. First, a summons of 2 months, and then a peremptory summons of 6 weeks. Until the 6 weeks of the peremptory summons had expired, it was impossible for him to proceed and for the cause to be set down ex parte. Before the cause can be set down ex parte, it is necessary that court should be satisfied of the fact of the two summonses having been served. The affidavit to satisfy the court of two summonses having been served was not made till November 1835. Then, for the first time, was the case ripe for hearing. Owing to the prosecutor not having appeared, and owing, if there was any delay, to the defendant not having previously issued the peremptory summons and made the proper affidavits of service. After having satisfied the court of the issue and service of those summonses, and the prosecutor not appearing, the case became, for the first time, ripe for hearing. Then it was for the only party before the court, namely the defendant, to have urged on the hearing if he had so thought fit, for at any time between November in the last year and the present time the case was ripe and might have been heard. No application, however, was made for a hearing. The defendant was satisfied that the case should take the course of the paper. The court, of course, could not, without any solicitation or any application, take any step for bringing on the hearing out of the usual course. If there has been delay, therefore, it has been partly from the default of the prosecutor and partly from the defendant not taking the steps he might have taken to obtain a more speedy hearing. 2nd December 1836, present Lord Brougham, the Vice Chancellor, Mr. Baron Park, Mr. Justice Bosanquet, Sir E. H. East, and Sir A. Johnston, on appeal from the Supreme Court of Bengal. James Young and others, Appellants versus the Bank of Bengal, respondent. Palmer and Co. were in the habit of taking up loans from the Bank of Bengal as well on deposit of company's papers as upon discount of their own and other negotiable securities. On November 12, 1829, they borrowed 1,03,900 rupees as a security for which they deposited and delivered to the said Bank of Bengal several government papers for different sums amounting in all to 1,13,000 rupees with authority to sell or dispose of the same on or after the expiration of 3 months from the above mentioned date and to render the surplus, if any, after satisfaction to the debtor company. On January 4, 1830, and whilst the said deposits were still in the hands of the bank, Palmer and Co. filed their petition of insolvency and were duly adjudged and declared insolvent. At the time of the said adjudication of insolvency, the bank were also holders and endorsee of two promissory notes, which at the time of action brought were wholly unpaid in their hands. Subsequently, on 15th February 1830, the bank sold and disposed of the company's papers, and after satisfying themselves in full out of the sale proceeds, there was a surplus left of 6,778 rupees, to recover which the assignees of Palmer and Co. brought an action to which the bank pleaded a set off on account of the two promissory notes which were then wholly unpaid in their hands. Held that the case did not come within the mutual credit clause of the Bankrupt Act. For repaying the monies advanced, Palmer and Co. could regain possession of the deposit, and the power of sale was determined without any consent of the party. Debts, in order to be set off, are supposed provable under the Bankruptcy Act, which is not the case here. Nor does the common law principle of mutuality, which is of the essence of set off, apply, for it is manifest that in the first place, had Palmer and Co. repaid the monies advanced on the deposit, the bank could not have retained the papers, and that in the second, had the bank brought an action upon the notes which they held as endorsees, Palmer and Co. never could have set off the surplus which might arise from the sale of the paper deposited. No doubt the case would have been otherwise had the bank actually sold the paper and received the surplus prior to bankruptcy. Lord Brougham. This was an appeal from the judgment of the Supreme Court of Calcutta in an action brought by the assignees of Palmer and Co. against the Bank of Bengal, in which a verdict had been taken by consent subject to the opinion of the court on a special case. The case stated that Palmer and Co. had been in the habit of obtaining loans from the bank on the deposit of company's negotiable paper as well as on the discount of their own and other securities. That in the month of November 1829, Palmer and Co. obtained in this way six several loans from the bank, amounting in the whole to 4,17,000 Sikka rupees, depositing company's paper to the amount of 4,60,000 Sikka rupees, and giving their own promissory notes at 3 months' date for the sums thus advanced by the bank. By these six several promissory notes, Palmer and Co. engaged to pay the several sums advanced with interest, and each note contained a further statement that so much company's paper had been deposited as a collateral security with an authority to the bank to sell the paper deposited for the reimbursement of the bank at the expiration of the 3 months credit, rendering to Palmer and Co. any surplus arising from each sale, and with an undertaking of Palmer and Co. to make good any deficiency and to pay 12% interest from the expiration of the credit until the debt should be discharged or the paper be sold. The several credits expired in February 1830, the first on the 15th of that month, the last on the 28th and on the 4th January, while the whole of the loans remained unpaid and the whole of the deposits were in the hands of the bank unsold. Palmer and Co. were adjudged insolvent under the 9th George 4 C73 and the plaintiffs were appointed assignees of their estate and effects. At the same period, the 4th January, the bank held two promissory notes of Palmer and Co. at 3 months' date for 40,000 and 60,000 Sikka rupees, payable the former the 24th January and the latter the 7th February 1830. These notes the bank held as indorsees for value, Palmer and Co. having discounted them with the bank in the ordinary course of business and before the first of the six loans, viz. On the 21st October and the 4th November 1829. None of the loans paid by the insolvents or their assignees, the bank proceeded to sell the paper deposited according to the terms of the agreements, and there remained a surplus upon the six sales of 30,176 rupees 10 annas 8 pi after paying off the several loans with the interest stipulated. For this sum, with interest at 6% after the dates of the several sales, the action was brought. The bank sought to set off the sum due upon the two promissory notes, which they held as indorsees for value and which remained unpaid against this surplus of the deposits made upon the subsequent loans. And the court, on the case reserved, being of the opinion that this set off was competent to the bank, gave judgment for the defendants, which was entered up on the 29th August 1833 and is now brought before this court by appeal. The act under which the proceedings were had upon Palmer and Co.'s insolvency, 9th George 4, Clause 73, contains a provision, Section 36, similar to the 56th section of the English Act, 6th George 4th, Clause 16, touching mutual debts and credits, and although there are some words of the latter omitted, particularly those respecting mutual debts between the parties and those requiring the commissioners to state the account between them, yet as there is a very general declaration that so much debts due and claims as may be proved under a commission of bankruptcy according to the act of the 6th George 4 may also be proved in a proceeding under this act in the same manner and subject to the like directions, conditions and provisions as in the 6th George 4 are set forth and presumed and prioritized and prescribed. End of quote. It is manifest that the proceedings are entirely assimilated, that the difference in the preceding portion of the section is immaterial, and that the present question is to be dealt with and disposed of exactly as if it had arisen in a proceeding in bankruptcy under the English Act. It is equally clear that in this case, the question turns upon the right of set-off given by the statute which extended the set-off recognized by the common law. Anonymous 1 Mod 215 Peters vs. Soam 2 Vernon 428. But for that extension, it never could be contended that the bank had a lien upon the securities deposited beyond the amount of the money advanced upon the credit of those securities. Since even in the most favorable view which could be taken, that of the bank being Palmer and Co.'s bankers, the lien for the general balance of the customer's account would in this case be restricted by the circumstances in which the deposit was made. This is clearly admitted in Davis vs. Boucher 5 TR 488, where the general lien of bankers was perhaps first distinctly ascertained. Nor can it be said that the debt due by Palmer and Co. on the promissory notes discounted had any connection with the deposit of the securities, Further debt was contracted before those securities were deposited, and the bank could not have had them in contemplation when it discounted the notes. The claim of the bank is accordingly rested upon the 50th section of the Bankrupt Act, which is taken from the 28th section of the 5th George II, Clause 30, with such additions as were supposed necessary for enabling contingent debts to be set off, since these were by the new Act made provable. Every debt or demand made provable by the Act against estate of the bankrupt may, by this 50th section, be set off against such estate, that is, against any debt or demand of the bankrupt's estate. But the former provision is retained with the addition of the word demand taken from the 46th George III, namely that where mutual credit has been given by the bankrupt and any other person, or where there are mutual debts between the bankrupt and any other person, the commissioners shall state the account between them, and one debt or demand may be set against another, and the balance only be claimed or paid on either side. The question then is whether or not there are mutual credits or mutual debts between the parties to the transaction now under consideration. That there was both a debt from Palmer and Co. to the bank and a credit from the bank to them is undeniable. The company were both previously indebted on their notes discounted and by the money advanced on the deposits. But that is not enough unless either the bank was indebted to them or they had given the bank credit. The only question then is, had Palmer and Co. or had they not given the bank credit before the bankruptcy within the meaning of the Act? In other words, was the deposit of the negotiable paper with the power to sell and pay over the surplus in case the advance made on it should not be repaid, a credit given to the bank by Palmer and Co. If it was a credit, we may further observe that it was so only to the extent of the surplus, for as far as regarded the monies advanced to secure which the deposit was made, that deposit was only in presenti a bailment, and even in futuro a payment of Palmer and Co.'s debt to the bank. The question is whether or not the deposit, quote the overplus, amounted to a credit given, whether or not Palmer and Co. giving the bank a power to possess itself of the surplus after repaying its own debt when that debt should become due can be said to be a giving credit to the bank. Although, generally speaking, debt and credit are correlative terms, and A credit to B may seem to imply that B is indebted to A, yet it may be added that the introduction of the words mutual credit extends the right of set off to cases where the party receiving the credit is not debtor in presenti to him who gives the credit. Accordingly, the relation contemplated by the statute has been held to be established where the debt is immediately due from the one party and only due at a future day from the other. It was so held in Ex parte Prescott 1 ATK 230, where the mutual credit was constituted by simple contract debts presently due on the one side and a specialty debt not due on the other. Smith versus Hodgson 4 TR 211, Hankey versus Smith 3 TR 507, and many other cases affirm the same doctrine. But in those cases, was there any uncertainty as to the party said to receive the credit becoming sooner or later debtor in presenti to the other? In none of them did the existence of the relation of debtor and creditor depend upon the pleasure of one party. In all of them, the party said to have given the credit had placed the other party in a situation which he himself could not alter, had given him funds of which he could not dispossess him, or which is the same thing, a power over funds which he could not revoke. The case is materially different where one of the parties has actually become indebted to the other and can only cease to be so by paying the debt, but the other has only acquired a power which may end in making him debtor or not, according as the donor of the power pleases. A is indebted to B and B is neither actually indebted to A nor under any liability which must needs end in his being A's debtor, but has only been entrusted with the power over A's funds to be executed at a future date if A pleases. But if A thinks proper, never to be executed at all. Admitting that in the event of A never revoking the power, a debt will arise, the existence of that debt is defeasible. The only certainty is that A, in order to revoke the power, must do an act wholly unconnected with giving B any credit, namely discharge a debt due to B. Now, it is not denied that Palmer and Co. could at any time have prevented the bank from ever receiving the surplus. In respect of the possibility of which surplus arising, the credit is supposed to have been given. By repaying the monies advanced, they could regain possession of the deposit, and the power of sale was determined without any consent of the pani. Again, not only existence of any debt at any other time depend upon the depositor, but no such debt as could have been proved under a commission against the pani. The words and every debt or demand hereby made provable to the recent act for the purpose of including contingent debts. The debts in order to be set off are supposed provable, which indeed appears to follow from the nature of the case. Suppose the Bank of Bengal had been made bank selling the paper. It is clear that Palmer and Co. could not have proved against their estate for the contingent surplus. The paper was deposited to answer a specific purpose, and if any use had made of it inconsistent with the terms of the deposit, the pani would have committed an offence, a breach of trust, certainly a transportable misdemeanor if the Bankers Act 52nd George III, Clause 63 extends to Bengal. But unless the power of sale was executed by the pani, in which case he became the debtor at once, he never could be said to have contracted a debt, either present or contingent, to the pawners, and consequently the pawner could make no proof. Next, it must be observed that though the question is on the statute, and though the statutory right of set-off extends the right known to the common law, yet the common law principle of mutuality, which is of the essence of set-off, must prevail. And if the deposit, or rather its surplus, could not be set off against the demand of the pani, so neither shall the pani's debt be set off against the surplus. Lord Hardwicke appears to have mainly proceeded on this view in Ex parte Ockenden, 1 Atkinson 235. Could the miller, he asks, have refused to deliver up the corn in an action at the corn factor's instance by claiming to set off a debt due unconnected with the deposit? And vice versa, could the corn factor have set off the value of the corn in an action by the miller for money lent at a former time? Holding that both questions must be answered in the negative, he considers this as decisive against the miller's right to set off the debt antecedently due from the pawners. And Lord Mansfield, in giving the judgment of the Court of King's Bench some years after, in Green versus Farmer in 4 Burrow 2224, after reading his own note of ex parte Ockenden, observes that Lord Hardwicke thought he could not construe a dealing to be within the natural mutual credit clause of the Bankrupt Act unless it could be construed in an action of trover, and adds that is certainly so. But if the same test be applied to the present case, there is an end of the question. For first, no one contends that had Palmer and Co. repaid the monies advanced on the deposit, the bank could have retained the paper for their antecedent debt, which is one of the points made by Lord Hardwicke. And next, had the bank brought their action upon the notes which they held as indorsees, it is manifest that Palmer and Co. never could have set off the surplus which might arise sale of the paper deposited, which is the second of Lord Hardwicke's points. No doubt the case would have been altogether different had the bank actually sold the paper and received the surplus prior to the bankruptcy. For then, they would have been debtors in that amount to Palmer and Co., and the case would have been one of debts. Supposing the notes discounted then due, or supposing them not yet due, it would have been a case of credit given to Palmer and Co. by them and of debt due from them to Palmer and Co. and so clearly within the statute. This is the case of Atkinson versus Elliott in 7 TR 378, but is wholly different from the case at bar. There is nothing inconsistent with what has now been advanced in the decision in the language used by the Court of Common Pleas in the case of Rose versus Hart, 8 Tount 499, where the former case of Olive versus Smith, 5 Tount 56, was reconsidered and a material qualification added to the generality of the doctrine which had there been laid down. In Olive versus Smith, a broker had been allowed to set off a debt antecedently due from his employer against the losses recovered from the underwriters on policies deposited in his hands. In Rose versus Hart, the court held that such a set-off is only competent to the pani in cases where the thing alleged to be a giving of credit either constitutes a present cross debt or must end in one. This limitation of the case of Olive versus Smith has, in subsequent cases, been approved and followed. Sampson versus Burton, 2 Broad and Bing, 89. Rose versus Sims, 1 Barn and Adol, 5521. And although the court in Esom versus Cato, 5 Barn and Adol, 861, appeared to hold that it was enough if the transaction would most likely terminate in a debt, yet it is to be remarked that the argument went entirely upon other grounds, and the decision cannot justly be said to have relaxed the restriction by which the Court of Common Pleas had, in Rose versus Hart, quoted its former opinion. If it can be admitted that there can arise no right of set-off in respect of mutual credit unless the dealing be at the time of the bankruptcy, such as must necessarily and at all events terminate in creating the relation of debtor and creditor between the parties, then is the present case out of that rule and the bank's claim of set-off defeated. Nor will the reversal of the judgment below be found repugnant to any of the cases except ex parte D's 1 Atkinson 228 and Olive versus Smith, of which the latter appears to have proceeded almost, if not altogether, upon the authority of the former, not to mention that it falls in some manner within the scope of Lord Mansfield's observations in French versus Fenn, to be afterwards cited. It is impossible to regard ex parte D's as resting on the ground upon which the report in Atkins places it. And although Lord Mansfield in Green versus Farmer seems to vouch for the accuracy of that report as well as of the report in the same book of ex parte Ockenden, he nevertheless refers to Lord Hardwicke's statement in the latter case that in the former there had been some evidence of a usage and gives it as the result of his own inquiry respecting ex parte D's that the packer, the pani, was by the usage in the nature of a factor. A reference which we have made to Lord Hardwicke's original notebooks has confirmed this statement that the point of usage was made and evidence adduced respecting it. From hence and from Lord Hardwicke's subsequent decision in ex parte Ockenden, as well as from what has been said both in the common pleas in King versus Flint, 8 Taunton 21, and by Lord Eldon in ex parte Flint, 1 Swanton 30, it may be considered that ex parte D's is no longer law as reported in Atkins, and that but for a special custom giving the pani a general lien, the mere deposit whether of goods or of securities for a particular purpose, as it certainly will not constitute the pani a debtor, so it will not amount to a giving of credit at all unless coupled with an authority given to the pani of selling them, such power being given absolutely and not countermandable. But it is equally certain that Olive versus Smith was decided upon the assumption that ex parte D's is a binding authority, and when we find that the language of the court in Rose versus Hart so materially varies and narrows the principle which had been the guide in the former decision, and that the case itself is disposed of in a way not easily reconcilable with Olive versus Smith, and in no way whatever reconcilable with the report of ex parte D's upon which Olive versus Smith had been grounded, and that the view now taken may be reconciled with the latter and more correct, or rather more authentic opinions of Lord Hardwick, and with the latter and more corrupt opinions of the Court of Common Pleas, there seems to be no good reason for supporting a claim which is but both at variance with the principle and runs counter to a great weight of authority than can be produced in support of it. With respect to the case of Parker versus Carter, 1 Cook, Bankrupt Law 548, it may be observed that the defendants rested their title to set off upon a lien which they claimed to have as general agents of the bankrupt, and the report of the case in Cook's Bankrupt Law gives this as the ground of the decision in their favor. Lord Chief Justice Gibbs in Olive versus Smith, though on the granting of the rule nisi, states Parker versus Carter as a case of mutual credit, yet afterwards, the particulars having been inquired into, seems to admit that it was a case of lien, 5 Taunt, page 65, and accordingly he rests his judgment mainly upon ex parte D's and mentions also ex parte Boyle, 1 Cook, Bankrupt Law 561, and French versus Fenn. Ex parte Boyle was the case of a client who owed a sum to his solicitor for work done and money lent, and who gave the solicitor, by way of loan, his notes on hand to a larger amount, part of which notes were not due and not paid by him till after the solicitor's bankruptcy. There, the notes, being payable to the solicitor's order at the client's bankers, were treated as a loan by the parties. At the date of the bankruptcy, the lender of the notes had become liable to pay, at all events, the contents of them to holders chosen at the solicitor's pleasure, they being made payable to the order of the solicitor, and nothing could prevent this liability from ending in a debt from the solicitor to the client, but the solicitor himself repaying the money advanced upon them. The client could not, by any act of his own, prevent his money coming into the hands of the solicitor or of the payee chosen by him to a fixed amount and at specified times. This case, therefore, comes clearly within the restriction imposed by the case of Rose versus Hart on the doctrine laid down in Olive versus Smith. And the same observation applies to ex parte Wagstaff 13 Vesey 65, where the credit in question arose from an acceptance of the bankrupt, payable after the bankruptcy but certainly payable then. The case of French versus Fenn, 1 Cook, Bankrupt Law 536, is also distinguishable from the one at bar, although it must be allowed to have gone further than any decision which preceded it, excepting ex parte D's. But it does not appear that the debt against which the price of the pearls when sold was allowed to be set off was in any part contracted before the agreement respecting the pearls. And Lord Mansfield expressly says that Fenn had trusted Cox the bankrupt with other goods, which in all probability he could not have done but for the pearls being left in his, that is Fenn's, hands. This would make the case nearly the same with D. Mainbray versus Metcalf, 2 Verne 698, where Lord Cowper relies mainly upon the debt set off being, in first, an advance made on the pawn. Lord Mansfield in French versus Fenn seems also to rely much on the circumstances peculiar to that case of the other two partners in the adventure, Cox and Halford, having agreed to allow Fenn interest on the money which he had advanced to pay for the pearls in the first instance. And one thing is quite clear, is that by the nature of the transaction, the rights of each partner until sale being to an undivided third, and Fenn having the deposit for sale, neither of the others could have obtained his share. Nay, both the others joining could not have obtained their share, nor gotten the whole pearls out of the Pani's hands, until the sale, which must at once render the credit to the Pani certain. If it be said that Cox might have assigned his right to his share of the eventual price minus his proportion of the purchase money, in the same way that Palmer and Co. might have assigned their right to the contingent surplus, then it must be also observed that this consideration takes the case out of the rule laid down in Rose versus Hart and could not stand with the decision in Rose versus Hart. It ought to be observed further that ex parte D's was relied upon simply by Mr. Justice Buller in deciding French versus Fenn. Both Lord Mansfield and Mr. Justice Buller seem to have been very much influenced by what they term considerations of general justice. Upon the whole, then, we are of opinion that the judgment in this case must be reversed and that the verdict taken by consent, subject to the opinion of the court, could stand and the postia be delivered to the plaintiffs. The interest too must be calculated subsequent to the time up to which the verdict for interest was taken, and this must be added to the verdict. December 7th, 1836. Present Lord Brougham, Mr. Baron Parquet, Mr. Justice Vaughan, the Chief Judge of the Court of Bankruptcy, Sir Hyde East, and Sir Alexander Johnston. On appeal from the Court of Sadar Divani Adalat of Bombay, Bhai Chand and Kushal Chand has to the estate of Roop Chand Keem Chand, deceased, appellants, versus Partap Chand Manik Chand, respondent. B brought an action against Pre on a promissory note given by P's ancestors to B's ancestors. The action was commenced nearly 27 years after the accrual of the cause of action and was clearly barred by the 13th article of Regulation 1 1800 of Bombay, which allowed only 12 years' time unless the plaintiff showed that from some good and sufficient cause he had been precluded from obtaining redress. In the present case, the plaintiff sought the protection of this exception by alleging that the defendant had been continually residing in Pune, which was within the jurisdiction of the Peshwa and beyond that of the company's court. Held that the continued residence of the defendant at Pune, in the absence of any evidence to show that the plaintiff might not, by adopting proper steps, have obtained redress in the Pune court, was not a good and sufficient cause within the meaning of the regulation. The Chief Judge of the Court of Bankruptcy, the Right Honorable T. Eskin. This was an appeal from the decree of the Sadar Devani Adalat at Bombay, which formed the last of a series of proceedings in the court of that province upon the question now pending for the final decision of His Majesty in Council. The first of these proceedings was a complaint filed in the Zilla Court at Surat in the year 1819 against Roop Chand, since deceased, by the present respondent Partap Chand, suing in forma pauperis, in which he claimed as heir of late uncle Pana Chand the sum of Sikka rupees 3,477 and an equal amount of interest upon a note of hand alleged to have been given by Roop Chand in the year 1792 to Karam Chand, the partner of the respondent's uncle Pana Chand, to secure the amount of the balance then due from Roop Chand to the partnership, After several intermediate proceedings in the Zilla Court and in the Sadar Adalat, which it is not necessary to particularize, during which the defendant Rupchand died and the present appellants intervened and were admitted to defend the suit. The cause came on before the Zilla Court for final hearing on the 14th February 1823. The defense set up during these proceedings by Rupchand and afterwards by his heirs was first that Rupchand never owed anything to Panachand or Karamchand. Secondly, that the note produced had been fraudulently abstracted from the widow of Karamchand by the plaintiff, who had no legal interest therein or right to sue thereon. Thirdly, that the supposed cause of action had arisen more than 12 years before the commencement of the suit and was therefore barred by the regulations of the company. In reply to the first defense, the plaintiff relied upon the reproduction of the books of account and the note. In reply to the second defense, it was stated that after the death of Karamchand and the respondent's uncle Panachand, he, the plaintiff, came to a settlement of the partnership accounts with the widow of Karamchand, who, having received from him her dues, gave him a deed of release, whereupon he took possession of the daftas and the note as having the exclusive right to them. In reply to the third defense, he relied upon the fact that the note was executed at Pune, where Rupchand resided, and that he had never been at Surat since until just before the commencement of the suit. And further, that Rupchand, on his arrival from Pune in 1819, had admitted the justice of his claim and had offered to pay a sum of money by way of compromise. The widow of Karamchand was examined upon interrogatories exhibited by the direction of the court and stated in substance that the note had no reference to any partnership concern between Karamchand and the plaintiff's uncle Panachand, but was given for money due to her husband alone, and that the release was executed by her without reading it and was intended to relate only to charities and other like expenses. That at the time she executed it, she did not give the note to the plaintiff, but that he stole it together with her books and papers. The Zilla Court, upon consideration of the whole case, was of opinion that the evidence of Karamchand's widow was fatal to the plaintiff's claim, and also that the plaintiff had not shown any proof of why the statute of limitations of 12 years should not bear upon his case, and therefore passed judgment against the plaintiff and decreed that one half of the defendant's cost should be recovered from the defendant and the remainder from any property that might be found to belong to the plaintiff, and the fees of the plaintiff's vakil should also be recovered from any property found to belong to the plaintiff. The cause was then carried back by appeal to the Sadar Adalat, before which fresh evidence was taken relative to the several questions raised before the Zilla Court, and on the 3rd June 1823, the second judge, before whom the cause was heard, recorded his view of the case, declaring his opinion for the reasons therein stated that the decision of the Zilla judge should be received and the amount of the note with interest and costs in both courts should be awarded to the plaintiff below, and these appellants having referred the case for the consideration of the full court. Afterwards, on the 26th of the same month, the rest of the court, after considering the documents and proceedings, concurred generally in the view taken by the second judge and determined to reverse the decree passed by the Zilla Court at Surat, and decreed that the sum of Sikka rupees 6,954, 3 annas be paid to the appellants by the heirs of Rupchand with full costs in both courts. Against this decree, the present appeal has been lodged, and the case was argued before this board on the 7th December last, when the counsel for the appellants insisted, first, that the respondent had made out no right of action against Rupchand or his heirs; secondly, that as the supposed cause of action had arisen beyond the jurisdiction of the court at Surat, and as the defendant Rupchand was not resident within it as a fixed inhabitant, but had only come to Surat for a temporary purpose, the Zilla Court had no jurisdiction on the case. And thirdly, that the plaintiff's right of action, if it ever existed, had been barred by the lapse of time. Their lordships intimated their opinion in the course of the argument that the plaintiff's title to sue, unless he had been barred by the lapse of time, was sufficiently established by the evidence, and that as the heirs of Rupchand had intervened in the suit and there was no evidence that they were not resident at Surat, where Roopchand had formerly lived, no objection could be raised by them to the jurisdiction, especially as no such point was made by them in either of the courts below, where the fact could have been easily ascertained. It is therefore unnecessary to say anything now upon those points, and the less so because their lordships are of opinion that upon the third objection, the decree of the Sadar Adalat must be reversed and the plaintiff's suit dismissed. The objection was founded upon the first regulation of the Governor of Bombay conferred in Council in August 1800 for the institution of a court of justice at Surat. By the 13th article of that regulation, the judge of that court is prohibited hearing, trying, or determining the merits of any suit whatever against any person or persons if the cause of action shall have arisen 12 years before any suit shall have been commenced on account of it, unless the complainant's case show by clear and positive proof that he had demanded the money or matter in question, and that the defendant had admitted the truth of the demand or promised to pay the money, or that he directly preferred his claim within that period for the matter in dispute to a court of competent jurisdiction to try the demand and assign satisfactory reason to the court why he did not proceed in the suit, or that either from minority or some other good and sufficient cause he had been precluded from obtaining redress. In this case, the cause of action was 27 years before any suit was commenced. Unless, therefore, the respondent can bring himself within one of the exceptions to this prohibition, the dismissal of the complaint by the Zilla Court of Surat must be held to have been right and the decree of the Sadar Adalat erroneous. The respondent contended and the Adalat decided that the case was brought within two of the exceptions. First, that the defendant had admitted the truth of the demand, and secondly, that the plaintiff was prevented by the defendant's continued residence at Pune, where the note was given, from procuring a settlement of the bond, and that he had thereby shown that by a good and sufficient cause he had been precluded from obtaining redress. The evidence upon which the supposed admission by Roopchand of the truth of the plaintiff's demand rests is to be found in the depositions of Kushal Chand, Panachand, and of Vakchand, Jaichand taken before the Sadar Adalat. But when this evidence is examined, it will be found to amount to no more than an offer of a specific sum of money by way of compromise, in no way involving an admission of the justice of the plaintiff's demand, further than what may be inferred from the offer of any compromise, an inference which is never permitted and which, in this case, would be most unfair when the action was commenced while the defendant was absent for a temporary purpose from his usual place of business to which he was anxious to return. Their lordships, therefore, are of opinion that the facts stated by those witnesses ought not to be taken as proof of any admission by the defendant of the matter of the plaintiff's defense, so as to take the case out of the prohibitory clause of the 13th article of the regulation. The only other ground upon which the plaintiff seeks to be exempted from the effect of the prohibition is the continued residence of the defendant at Pune. But no evidence is to be found in any of the proceedings to show that the plaintiff might not, by adopting proper steps, have obtained redress in the Maratha courts at Pune. It was stated, indeed, in the course of the argument that it was useless for a poor man to commence proceedings against a wealthy opponent in the Peshwa's court. But their lordships cannot, in the absence of all proof, judicially assume this as a fact. It was also urged that the decision of the judges of the Sadar Adalat, who must be presumed to know how justice was administered in the native courts, might be taken as evidence. That the plaintiff could not have procured redress there if he had attempted it. But the second judge, who alone gives any reasons for the decree, does not assign this as the reason why the plaintiff was prevented obtaining an earlier settlement of the bond at Pune. And we have upon this fact the opinion of the Zilla judge the other way. Their lordships, therefore, are of opinion that they ought not to adopt these vague surmises as a substitute for the clear and positive proof required by the regulation in question. If their lordships had found that, by a train of decisions in the court abroad, the residence of the defendant beyond the limits of the jurisdiction of the company's court had been considered a good and sufficient excuse for the complainant's delay beyond the 12 years, they would have considered themselves bound by a practice upon which the plaintiff might fairly be presumed to have relied. and the case has been allowed to stand over for the purpose of enabling the counsel of the respondent to produce any such decisions. But none can be found. In the absence, therefore, of authority, their lordships can find no principle on which they can determine that the residence of Rupchand at Pune afforded such an obstacle to the plaintiff's obtaining earlier redress as to exempt him from the effect of the prohibition under discussion. The learned counsel for the respondent relied very much upon a decision in this country in the case of Williams versus Jones, 13 East R 439. But the point argued and decided in that case was essentially different from the case now under discussion. In that case, the plaintiff's claim was clearly brought within the express exception of the statute, but it was contended that his right of action was gone because by the adoption of the statute of limitations in India, where the contract was made, his remedy had been barred there by the lapse of time, and the decision of the court proceeded upon the ground that as before the statute of limitations, the plaintiff's right of action in this country had no limit, and as the circumstances of the case exempted it from the operation of that statute, his remedy could only be barred by the extinguishment of his right. And as the adoption of the statute of limitations in India could only bar his remedy there, but did not extinguish his debt, his remedy in this country remained unimpaired. But in this case, the only question is whether the plaintiff's proof brings him within the exceptions. Their lordships are of opinion that it does not. He has neither proved an admission of the truth of his demand, nor that by a good and sufficient cause he has been precluded from obtaining redress within the time limited by the regulations. And therefore, their lordships will recommend His Majesty to allow this appeal to reverse the decree of the Sadar Adalat and to affirm the sentence of the Zilla Court. Second, 3rd, and 12th December 1836. Present members of the Judicial Committee, Lord Brougham, Mr. Baron Park, Mr. Justice Bosanquet, the Chief Judge of the Court of Bankruptcy, Privy Councillors, Assessors, the Right Honourable Sir Hyde East and the Right Honourable Sir Alexander Johnston, on appeal from the Supreme Court of Bengal. The Mayor of the City of Lyons in the Kingdom of France, acting for and in the name of the community of the City of Lyons, and Christophe Martin, Marie Desanges Martin, widow of Louis Martin, deceased, Pierre Balafet, and Claudine, his wife, and Francois Martin, appellants, versus the Honorable the East India Company and His Majesty's Attorney General, respondents. General Martin, a native of France but a servant of the East India Company, made a will which contained, among other things, directions to the effect that certain sums should be set apart for the liberation of persons imprisoned for debt, as well as for the endowment of a college at Lucknow in the dominions of the king of Oudh. A suit having been instituted to administer the will, the master reported that the king of Oudh objected to the release of the prisoners but would have no objection to the establishment of a college. The report of the master was confirmed, but on a second hearing of the cause, the court directed a fresh inquiry as to whether the Governor General in Council had the means of giving effect to the bequest to the college, whereupon the master reported that the Governor General was willing to receive the funds without distinctly finding whether he had the means of giving effect to the request to the bequest. Upon this report, however, the court decreed payment of the funds to the Governor General or such person as he should appoint. Held. The reference to the master on the second hearing was informal. The master should have found distinctly whether the Governor General had the means of giving effect to the bequest, and his not having done so, the inquiry was not complete. Held also that the bequest to the Lucknow College is not in the nature of a foreign charity which could not be carried into effect by the Supreme Court, but that having regard to the existing relations between the East India Company and the King of Oudh, there seemed sufficient grounds for expecting that the Supreme Court might find fit persons for administering that charity under its superintendence. Held also that General Martin, though an alien, was still capable of holding and devising real property in the East Indies, as the English law of aliens had no force here. Symbol. The statute of frauds does not extend to the East Indies. Freeman versus Fairley, which decided that the estate in land and tenements of a British subject in Calcutta was a freehold of inheritance, distinguished. Lord Brougham, the first and by far the most important question brought before us in this case is whether or not the testator, being an alien, could devise his real property. In other words, whether or not that portion of the English law which incapacitates aliens from holding real estates to their own use and transmitting it by descent or device extends to Calcutta and to the Mufassal. As the argument for its extending to Calcutta is very much stronger than that for its extending to the Mufassal, it may be well to consider the former in the first place. It is agreed on all hands that a foreign settlement obtained in an inhabited country by conquest or by cession from another power stands in a different relation to the present question from a settlement made by colonizing, that is, peopling an uninhabited country. In the latter case, it is said that the subjects of the crown carry with them the laws of England, there being, of course, no lex loci. The former case, it is allowed that the law of the country continues until the crown or the legislature change it. This distinction to this extent is taken in all the books. It is one of the 6 propositions stated in Campbell versus Hall as quite clear and no matter of controversy in the case. And it had been laid down in Calvin's case, in Dutton versus Howell, in Blanchard versus Gad, Salk by Lord Holt, delivering the judgment of the court, and nowhere more distinctly and accurately than in the decision of this court. 2 limitations of this proposition are added to which it may be material that we should attend. One of these refers to conquests or cessions. In Calvin's case, an exception is made of infidel countries, for which it is said in Dutton versus Howell that though Lord Coke gives no authority, yet it must be admitted as being consonant to reason. But this is treated in terms as an absurdity by the court in Campbell versus Hall. The other limitation refers to new plantations. Mr. Justice Blackstone says that only so much of the English law is carried into them by the settler as is applicable to their situation and to the condition of an infant colony. And Sir William Grant in Attorney General versus Stuart applies the same exception even to the case of conquered or ceded territories into which the English law of property has been generally introduced. Upon this ground, he held that the Statute of Montmain does not extend to the colonies governed by the English law unless it has been expressly introduced there, because it had its origin in a policy peculiarly adapted to circumstances of the mother country. Then, is Calcutta to be considered as an uninhabited district settled by English subjects or as an inhabited district obtained by conquest or cession? If it falls within the latter description, has the English law incapacitating aliens ever been introduced? If that law has never been introduced, has there been such an introduction of the English law? Generally, that those parts which have been introduced draw along with them the law touching aliens. An answer to these three questions, if it do not exhaust the argument, seem to carry us sufficiently near to the conclusion at which we seek to arrive, and it will include a consideration of the only reason for the proposition upon which the judgment below is mainly rested, viz., that the royal prerogative extends necessarily and immediately to all acquisitions, however made, and that the forfeiture of aliens' real estate is parcel of that prerogative. Number 1. The district on which Calcutta is built was obtained by purchase from the Nawab of Bengal, the Emperor of Hindustan's lieutenant, at the very end of the 17th century. The company had been struggling for nearly 100 years to obtain a footing in Bengal until 1696. They never had more than a factory here and there, as the French, Danes, and Dutch also had. Till 1678, their whole object was to obtain the power of trading, and it was only then that they secured it by a firman from the emperor. From that year till 1696, they in vain applied to the native government for leave to fortify their factory on the Hooghly, and it was only then that they made a fortification, acting upon a kind of half consent given in an equivocal answer of the Nawab. Encouraged by the protection which they were thus enabled to afford the natives, many of them built houses as well as the English subjects. And when the Nawab, on this account, was about to send a Cadi or judge to administer justice to those natives, the company's servants bribed him to abstain from this proceeding. Some years afterwards, the company obtained a grant of more land and villages from the emperor with renewed permission to fortify their factories. During all this period, tribute was paid to the emperor or his officer, the Nawab, first for leave to trade, afterwards as zamindar under the emperor, and in 1757, the year memorable for the Battle of Plassey, the treaty with Jafar Ali, indemnifying them for their losses, ceding the French possessions and securing their rights, and binding them to pay their revenues like other zamindars. 8 years later, they likewise received from the native government a grant of the Diwani or receivership of Bengal, Bihar, and Orissa. And of their subsequent progress in power, it is unnecessary to speak. Enough has been said to show that the settlement of the company in Bengal was effected by leave of a regularly established government in possession of the country, invested with the rights of sovereignty and exercising its powers. That by permission of that government, Calcutta was founded and the factory fortified in a district purchased from the owners of the soil by permission of that government and held under it by the company as subjects owing obedience, as tenants rendering rent, and even as officers exercising by delegation a part of its administrative authority. At what precise time and by what steps they exchanged the character of subjects for that of sovereign, or rather acquired by themselves or with the help of the crown, and for the crown the rights of sovereignty cannot be ascertained. The sovereignty has long since been vested in the crown, and though it was at first recognized in terms by the legislature, in 1813 the statute 53 George 3 clause 155 section 95 is declaratory and refers to the sovereignty as undoubted and as residing in the crown, but it is equally certain that for a long period of time after the first acquisition, no such rights were claimed nor any acts of sovereignty exercised, and that during all that time no English authority existed there which could affect the land or bind any but English subjects. The company and its servants were then in the situation of the Smyrna or the Lisbon factories at the present time. The next question, number 2. The next question is, has the English law incapacitating aliens ever been introduced? It follows from what has been observed not only that Calcutta was a district acquired in a country peopled and having a government of its own, but that for a long course of time no such law as that which incapacitates aliens, could be introduced any more than it could now be introduced into such part of the Asiatic or Portuguese territory as those factories may occupy. But even where the sovereignty rested in the crown, there is every argument of probability against a law being introduced so inapplicable to the circumstances of the settlement. Sir William Grant's reasons for confining the Mortmain Act to England have a manifest application to this case, for though they are mainly drawn from the provisions of that act being adapted to the peculiar circumstances of the mother country, they plainly proceed upon the assumption that the intention of the legislature to confine the operation of the act may be gathered from thence. And it should seem that such intention is even more directly to be gathered from the fact that the provisions in question are manifestly inapplicable to the circumstances of the settlement. At whatever time the sovereignty was acquired and the power of introducing the alien law became vested in the crown, the real property in Calcutta must have been held indiscriminately by subjects and foreigners. The sudden application of such a law is, in the highest degree, improbable because it would work great inconvenience and grievous injustice. But if the sovereignty was gradually acquired, if the transition of the company from the state of subjects under the Mughal to an independent authority was slowly made by imperceptible steps, the introduction of the alien law became still more improbable. For no act could then be done by the party obtaining the dominion, nor any stipulation made by the party becoming subjects to secure the rights of one or restrain the power of the other. This may always be done where a conquest or cession at once vests the sovereignty of a district in one state which had previously belonged to another. The treaty may ascertain and almost always does ascertain the relative rights of the parties as to the property of the country. But in the present case, no such definition could possibly take place. And this exceedingly increases the improbability of such a law having been introduced at all. Nor does the argument rest here. The well known facts are wholly inconsistent with the supposition that this law ever was in operation, and the acts of the sovereign power, the legislative acts of the crown and of those to whom its authority is delegated, and the acts of the parliament itself plainly proceed upon the footing of this law never having extended to Bengal. The facts must, of necessity, be numerous and of constant occurrence, for every foreigner holding a house by lease or by freehold tenure affords an instance of the law not being in operation, and no instance has been produced. Indeed, it is agreed on all hands that no instance has ever existed of a forfeiture to the crown for this cause. There is no such a thing known in those parts as an inquisition of office or any analogous proceeding or any proceeding whatever for entitling the crown or those exercising its delegated authority to the real estate or chattels real of aliens within the district. When those foreigners die, their real estates have descended to their heirs or been taken by their devisees or been administered as assets by their executors without any claim ever having been made by the sovereign power, which would here in England have been entitled without any office. Ejectments have been brought, and the parties in possession have never been advised to set up the defense that the lesser of the plaintiff claimed by descent from an alien, and dower has been assigned to widows alien also. Previous to 1826, which is a long time after the present proceedings were instituted and after the first decree in the cause, no mention of the subject appears ever to have been made in any place or in any court of justice. Assuredly, if the law be as is contended, and the crown by law is entitled, no one can contend that it is too late to declare the law and enforce the right. But the whole question turns upon this: has the law in question been introduced? And the non claim is material to show that it has not been introduced, because it is not merely the acquiescence of a party. It is the acquiescence of that power which alone possesses the right to introduce the law and affords strong proof that this power never had introduced it. But the acts of the same power afford positive evidence yet more distinct. The Charter of the 13th George I expressly states forth that the intention of the Crown is to induce foreigners to settle within the district. Quote, whereas the East India Company have, by a strict and equal distribution of justice, very much encouraged not only our own subjects, but likewise the subjects of other provinces and the natives of the adjacent countries to resort to and settle in the said towns, factories, and places, especially in Calcutta, Madras, and Bombay. End of quote. To enable them the better to administer justice, corporations of mayor and aldermen are constituted with power to administer justice. And it is expressly provided that of the aldermen, seven shall be natural born subjects, and two may be subjects of any other province or state in amity with the crown, and all of these are to be chosen from the principal inhabitants of the presidencies. In the successive renewals of this charter down to the end of George II, the only change in the province is adding the qualification that of the nine aldermen, the two foreigners shall be Protestants. This charter could hardly have been so worded had the crown intended that aliens should be incapable of holding lands, and it certainly could never have contained the provision directing two aliens to hold offices of trust under the crown, or directing all the aldermen, including the aliens, to be chosen out of the principal inhabitants, if the general capacities of aliens by the English law had been introduced into Bengal. For even if the disqualification to hold office can be traced no higher than the statute, there can be no argument raised in favor of the introduction of this part of the English law into Calcutta before the Statute 11 and 12 William III, Clause 44 was passed. Observe too in what way the supreme authority in Bengal, exercising the delegated powers of sovereignty, regards aliens, and mark if it views them as at all on a different footing from subjects in respect of rights of property. The Regulation 38 AD 1773 was made, as the title states, to enforce the quote, existing rules against Europeans of any description holding lands without the sanction of the governor in council. End of quote. In the third section enacts that, quote, no European of whatever nation or description shall purchase, rent, or occupy directly or indirectly any lands out of the limits of Calcutta without the sanction of the Governor General in Council, and all persons now so holding land beyond the limits of Calcutta without having obtained such permission in opposition to the repeated prohibitions of government, or who may hereafter so purchase, rent, or occupy land, shall be liable to be dispossessed of the land at the discretion of the Governor General in Council, nor shall they be entitled to any indemnification for buildings which they may have erected or other account. End of quote. No statute made for England could have been so framed. It would have been absurd to prohibit Europeans of whatever nation or description doing that which only one class of Europeans with British subjects could by law do. The provision of the Bengal regulation manifestly proceeds upon the assumption that persons other than subjects could, but for the prohibition and the former rules which it is made to enforce, have held lands. It declares that aliens as well as subjects shall be liable to be dispossessed of lands purchased contrary to the enactment, which would have been wholly absurd if aliens had been liable to be dispossessed upon office found whether the prohibition had been issued or not. It would be difficult to produce a clearer recognition that the sovereign power did not consider that the alien law had ever been introduced into Bengal. But it also seems to admit that in Calcutta, and notwithstanding the prohibition, foreigners as well as subjects might hold lands without license, for it confines the prohibition to them of a cell. Out of Calcutta are the words. The same inference is more strongly raised by the statute 9 George IV, clause 33, quote, for declaring and settling the law respecting the liability of the real estate of British subjects and others within the jurisdiction of the Supreme Courts in India as assets for the payment of the debts of their deceased owners. End of quote. It declares and enacts that when any British subject shall die seized of or entitled to any real estate in houses, lands, or hereditaments, or, quote, whenever any person not being a Mohammedan or Gentoo shall die so seized or entitled, then such real estate of such British subject or other person as aforesaid shall be assets, and it afterwards declares the executor or administrator of such British subject or other person entitled to sell and dispose of such real estate, and to convey and assure the same to purchasers in as full and effectual a manner as the testator or intestate could or might have done in his lifetime. Surely this could have no meaning unless persons other than British subjects, that is, aliens, could by law be seized of or entitled to real estate, and nothing could be more absurd than to declare that the executors and administrators of aliens shall be entitled to sell the real estates of aliens, testators of intestates, in as full and effectual a manner in law as the testators or intestates could have done, if those testators or intestates could not in any manner or way have sought or devised in any way have dealt with such estates. Suppose such an enactment in any statute relating to this country, and see how absurd it would have been. This seems strongly to prove that our law as to aliens was not understood by the legislature to have been introduced into India before 1828, and yet the earliest of the cases, the only one before the case at bar, had then been decided at Calcutta. But it seems to be contended But it seems to be contended here and below that there is something in the law incapacitating aliens which makes it, so to speak, of necessary application wheresoever the sovereignty of the crown is established, as if it were inherent in the nature of sovereign power. To this, a sufficient answer has been already afforded. If the acts of the sovereign power If the acts of the sovereign power to which we have referred show that no such application to Bengal ever was contemplated, unless direct authority can be produced to show that the right is inseparable from the sovereignty and as it were an essential part of it. Now there is no now there is no intimation of anything of the kind in those cases where the whole subject is discussed most at large, as in Calvin's case, where all the doctrines connected, however remotely, with each head of the argument are broached. Lord Hayes' famous judgment in Collingwood versus Face and Lord Mansfield's in Hall versus Campbell. But in the absence of any such authority, the distinct recognition by the sovereign of the capacity of aliens is itself a strong authority against the position which affirms the title of the crown to aliens' estate to be inseparable from the sovereignty. At the very least, it shows either that the right in question does not exist or that it has been waived and removed. It should seem, however, independent of these considerations, that there is no warrant in the nature of the thing for the position that this right is an incident of sovereignty. It certainly is not an incident to sovereignty. In several other countries, the sovereign has no such right. In France, for example, aliens can hold lands without entitling the crown and can transmit them to their heirs. This was abrogated by Ordonnance 13 October 1814, the droit d'aubaine having been abolished at the Revolution, and the proviso of reciprocity at the Restoration introduced, provided the law of their own country gives the same right to French subjects then seized of lands. Besides, if reference be made to the prerogative of the English crown, that prerogative in other particulars is of as high a nature, being given for the same purposes of protecting the state. And it is not contended that these branches are extended to Bengal. Mines of precious metals, treasure trove, royal fish, are all vested in the crown for the purpose of maintaining its power and enabling it to defend the state. They are not enjoyed by the sovereign in all or even in most countries, and no one has said that they extend to the East Indian possessions of the British crown. Number 3. Can it then be contended that the general introduction of the English law draws after or with it that branch which relates to aliens? This is the third question proposed, and to this an answer or the materials for an answer have already been furnished. For had the negative position only rested upon want of instances where the rights of the crown had been enforced, it might have been said that the general application of the English laws implied that of the portion in question. But the acts of the power which alone would introduce this portion and which alone introduced the English laws generally show that it was introduced not in all its branches but with the exception of this portion at least. This must be admitted unless it can be maintained that there is no possibility of introducing the English laws at all without introducing every part of them, which clearly cannot be asserted. For notwithstanding the extent to which the laws have been introduced, it is allowed on all hands that many parts of them are still unknown in our Indian dominions. The argument to which we are adverting assumes that the English laws regulating real property generally have been introduced, and for this position, the case of Freeman versus Fairley is cited. But that case only decided that the estate in land and tenements of a British subject in Calcutta was of such a nature as to descend to him according to the English law of succession, that it was freehold of inheritance. It is true that this conclusion was reached by the adoption of the larger position that the English law had been introduced into the settlement, but whatever went beyond the point of the land being freehold of inheritance was obiter and cannot be said to have been decided. It must further be observed that the grounds of the more general position were chiefly the practice of the settlement in regard to the mode of conveyances, viz. By lease and release with the course of succession, and also the charters of the company with acts of parliament referring to them, the charter of the 13th George I being the one principally cited. Now, no one who reads that able judgment can entertain a doubt that the same learned judge, had he been called upon to determine whether or not the law extended to alien incapacities, when he found the practice wholly against this extension without any exception, and when he also found the language of the charters, especially that of 1726, as well as the provisions of the regulations of 1793 and of the act passed in 1828, all proceeding upon the supposition of aliens being equally capable with subjects of holding and transmitting real property, would have decided against extending and applying to the law of alienage the proposition which he had laid down upon the facts then before him and upon the branches of the English law connected with the case under his immediate consideration. If indeed the whole English law of real property, or even all its principal provisions, have been introduced into these settlements, an event which must have taken place many years back, how came it to pass that as late as 1817 there could have been any question made whether or not wills to pass real estate must be witnessed according to the provision of the statute of frauds? Yet it was then, and while Freeman versus Fairley was pending before the same court, for the first time determined that those provisions extended to Calcutta. Determined too upon a full inquiry into the facts and examining evidence of persons conversant with the Indian law, and it is plain from the inquiry which Sir William Grant had directed and from what Sir Thomas Plumer afterwards says in giving judgment, that the mere proof of property being fee simple and inheritable by the English law was not deemed sufficient, but a further inquiry was directed whether it passed by will without more than two subscribing witnesses. Nor can any distinction be taken between that case and the present upon the ground that there the question related to the introduction of a statute, and that here the introduction of the common law is in dispute. For in Freeman versus Fairley, and in almost every question that can be raised touching the application of the forms of conveyance known in our law, the argument is confined entirely to assurances which are the creatures of statute. No instance has ever been produced of land passing in Calcutta by the common law conveyance of feoffment and livery. The introduction of the English law is proved by showing that the mode of conveyance is adopted by lease and release, that is, upon the statute of uses. Reference has been made both here and in the court below to the opinion of Sir F. Norton in 1764, and the true account of that opinion was given here, though it does not seem to be accurately understood below. It holds very distinctively that the subjects of a conquered or ceded territory are only to be considered as not being aliens by virtue of the treaty which gives them the rights of subjects, and that none but such as can claim the benefit of the treaty can hold or transmit lands. We say this is the purport of the opinion, and that it was so represented here. For indeed, the argument maintained by the Crown requires the proposition to be carried thus far, that upon a conquest of cession All the inhabitants continue aliens after the change of dominion unless and until the conqueror or purchaser grants their naturalization. But this position seems wholly untenable, for all the authorities laid it down that upon a conquest, the inhabitants ante nati as well as post nati of the conquered country become denizens of the conquered country. And to maintain that the conquered people become aliens to their new sovereignty upon his accession to the dominion over them seems extremely absurd, almost as inconsistent with the common sense as it would have been to hold the English inhabitants aliens under James I at a time when there was even a question raised whether the anti-nati of Scotland did not become by his accession denizens in England. The court below, it must be observed, distinctly admit that conquest operates what they term a virtual naturalization. But Sir F. Norton holds that without express provision in a treaty, the subjects conquered are aliens. Even if all the rest of the argument to be admitted, still it cannot be denied that the crown may relinquish its prerogative. Indeed, whenever the inhabitants of conquered provinces are held to obtain the rights of subjects by treaty, and even Sir F. Norton has no doubt of this being possible, those who hold the doctrine the most vigorously must say that the treaty is a voluntary abandonment of a right of the crown. It evidences the will of the sovereign to exempt the conquered territory from this branch of his prerogative. But the same will of the sovereign may be collected from other circumstances, and the like abandonment of the prerogative be thus evidenced. The charters, regulations, and the Act of Parliament, to which reference has so often been made, appear sufficient circumstances from which to collect this will of the sovereign, and so prove the abandonment in the present case. And this even upon the supposition that in consequence of the prerogative being generally admitted, the proof lies on those who would set up an exemption, on those who would show that the English law of forfeiture was not introduced into Calcutta, rather than on those who undertake the affirmative proposition. Upon the whole, their lordships are of opinion that the law incapacitating aliens from holding real property to their own use and transmitting it by descent or by device has never been introduced into Calcutta. There appears still less reason to hold that it has ever obtained a footing in the Mufassal. But into the additional grounds for differing with the court below, upon that part of the case it is unnecessary to enter, as we consider that the decree must be reversed upon the part relating to the Calcutta property, and therefore can have no doubt as to pursuing the same course with the part relating to the Mufassal property. Upon this branch of the cause, therefore, it will be necessary to reverse that part of the decree which declares that the testator, having been an alien at his decease, his lands and houses in Calcutta would not pass by his will, and that there was not evidence sufficient to determine whether or not the testator's lands and hereditaments in the Mufassal could pass by his will, together with the consequential directions, and then to declare that all the real property of which the testator died ceased within the presidency of Fort William, whether in Calcutta or not, except in Chandernagore, passed by his will and formed part of the residue. And an inquiry must be directed as to the nature and tenure of the property at Chandernagore and the usages and laws prevailing there, touching the right of an European alien to devise the same, confining the inquiry directed by the decree to such property, and to ascertaining what part of the funds now standing to the account of the cause has arisen from the rents and profits of the property at Chandernagore and the interest of those rents and profits. Section 2. The next point is raised by the course pursued below upon the Master's report of the 19th July 1830, the rehearsing 25th July 1831 and the Master's report of 1831, and this becomes very material as involving the question whether or not the court was concluded as to the bequest for Constantia College or the Lucknow charity by what the Master had in the first instance found and by his finding being confirmed. The decree 2nd September 1822 directing an inquiry whether the college could be established and whether the bequest of 4,000 rupees for liberation of prisoners at Lucknow could be carried into effect with reference to the testator's intention and the sanction and dispensation of the Lucknow government. The master, 3rd February 1830, made his report in the negative as to the 4,000 rupees following the words of the decree, and as to the college, he reported that there was not sufficient evidence before him to enable him to report, but as no further evidence was likely to be obtained, he annexed that which had reached him, the most material part of which was a statement of the resident that the king of Oudh would not object to the establishment but would hold out no expectation of his countenancing or supporting it. To this, an exception was taken on the ground that the master had not reported as directed, and the exception being allowed, it was referred back to the master, who reported 9th July 1830 that neither the establishment of the college nor the bequest of 4,000 rupees could, with reference to the testator's intentions and the sanction and disposition of the Lucknow government, be carried into effect. This second report was confirmed by an order made 17th February 1831, which stands still unaltered. Notwithstanding this, the court, on the rehearing, referring it to the master to inquire and report whether or not the Governor General in Council had the means of giving effect to the bequests above mentioned, and whether the Governor General would receive or authorize someone to receive the fund for these purposes. The master, on the 5th November 1831, reported that the Governor General was willing to do so and annexed to his report the letter of the Government Secretary stating that the government had no objection to apply the money through the government agent at Lucknow. But the master did not answer the most material question put to him, and he did not report whether or not the Governor General had the means of giving effect to the bequests. The court, however, on the 20th March 1831, confirmed the report and decreed that as it was unable to give effect to the bequest itself, and as the Governor General had the means and was able to give effect to the bequest and was willing to receive the fund, it should be paid over to him or such person as he should appoint. The irregularity of the whole proceeding is manifest. The master's report stands confirmed that the bequests could not at Lucknow be carried into effect, and the subsequent reference for inquiry, the report and confirmation with the decree proceeding upon it, could not be made while that order stood. In the courts of this country, there could be no doubt at all upon this head. Even this would have been set aside as of course. And although sitting in this place, their lordships are in the practice of refusing to let mere matter of form shut them out from the substantial merits, yet the irregularity and indeed the total inaptness of the proceeding is such as could not have been disregarded had it not been for one consideration of material importance. There was no party in the court below interested in objecting to this proceeding, or rather, indeed, all parties might be said to have an interest in letting the irregularity pass, and the first report with the order confirming it stands. Their lordships do not therefore think that they should satisfy the justice of the case, were they to suffer the objection now to be taken with effect, and the material portion of the decree to be thus frustrated. But it was fit to mark their opinion of the irregularity, which in any other circumstance must have proved fatal. There is another material consideration besides the one already stated in favor of getting over the irregularity in the present instance. The first inquiry and report set forth that the bequest could not be carried into effect with reference to the sanction and disposition of the government of Oudh. Now the evidence only states that the king of Oudh has no objection to the establishment, though he will not promise to encourage it by his countenance and support. The report then seems to go beyond the evidence as regards the college, though it seems quite correct as regards the 4,000 rupees. The inquiries afterwards directed apply to the proposed interference of the Governor General to aid the establishment of the college with the Lucknow government, and it may be contended that if the first report had been more in accordance with the evidence, there would not have been any material discrepancy between its finding and the subsequent inquiry. For the subsequent inquiry might be only to ascertain whether the means existed with the help of the Governor General. Then, supposing the irregularity got over, we come to the next question. Can the decree as to the application of the fund stand? Shall the fund be applied to the establishment and support of a college at Lucknow? Shall it sink into the residue and be divided between the two charities appointed to be established at Calcutta and at Lyons? For the cases of Attorney General versus Bishop of Landgraf and Attorney General versus Ironmongers Company, make it clear that in this case, which is indeed stronger than either of those, The other two charities must take if the gift fails as regards the third. If the fund is to be applied in Lucknow, shall it be applied as the decree directed or in what other way? But it must here be observed that the decree assumes the master to have reported on the evidence before the court, to have proved that the Governor General has the means of giving effect to the bequest at Lucknow. But this nowhere appears in any way. The report of the 5th November 1831 states that the inquiry directed had been made with whether the Governor General had the means of giving effect to the bequest and was willing to receive the fund and apply it, but only adds that the Governor General was willing without stating whether or not he had the means. The correspondence annexed to the report contains a question put to the Governor General by the company's acting attorney whether or not by the court declaring its own inability to give effect to the bequest, but stating that the Governor General had the means of so doing and was willing to receive and apply the fund, would be proceeding upon a right construction of the Governor General's former answer that the services of the British officer at Lucknow would always be available for the purpose required. The answer of the Governor General avoids the question as to his having the means and only states that if the court chooses to leave the entire matter to the government, he sees no objection to the transfer the duty to the agent at Lucknow and will receive and apply the fund. In returning this answer, the government secretary refers in terms to the words of the proposed decree as stated in the question put by the company's acting attorney, and as he is silent upon the material portion of those words referring to the Governor General having the means, there seems room to doubt that the question is purposely avoided. We do not therefore think it possible that this part of the decree can stand because the foundation is removed on which it is rested. The court must have an answer to the inquiry and a reasonable ground for assuming that the bequest can be carried into effect before it can part with the fund. But the manner in which it is proposed to part with the fund is also, in our opinion, improper. The court gives the control of it not to any party or any competent authority pointed out by the testator, as was done in the case of the Provost and Bailiffs of Edinburgh versus Aubrey in Oliphant versus Henry, and the other cases of this class, nor does it give the control and management to any person under its own superintendence and amenable to its jurisdiction. Giving it to the government is letting go all hold over it and at once departing with its jurisdiction to those who can never in any way be interfered with or called to account. It appears clear that if the court had been satisfied of the means existing for effecting the testator's purpose at Lucknow, there should have been appointed a trustee or trustees for applying the fund under the superintendence of the court, and that these trustees should therefore have been persons residing within its jurisdiction, and if officers of its own, so much the better. This part of the decree must therefore be altered by reversing the part which declares that the Governor General had the means and was able to give effect to the bequest for the college at Lucknow, and such part of the consequential directions as relates to paying over the fund to the Governor General or person appointed by him. But the part of the decree declaring the bequest of 4,000 rupees void is to stand, and also the part relating to sums which may be due to persons on account of any expenditure already made at Lucknow. Then for the part reversed, there must be substituted a direction that further inquiry be made as to the power of the Governor General to aid trustees to be appointed by the court in giving effect to the bequest regarding the college, and if the court shall be satisfied that in this or in any other way such trustees can give it effect, then the fund is to be paid over to such trustees who are to report from time to time to the master and to administer the fund under the superintendence of the court. The court giving such directions as may be necessary to establish the charity according to the will. Their lordships are well aware that in pursuing this course they are sanctioning a proceeding for which there is no exact and complete precedent in the administration of charitable funds in this country. But in one respect there is sufficient authority which, as far as regards a postponement of distributions and the not declaring the gift void on account of any present difficulty in giving it effect. The case of Attorney General versus Bishop of Chester furnishes a direct authority for not declaring a legacy void because it was for an object which could not at the time be accomplished, and for retaining the fund in court until it should be possible to apply it. No doubt if, in that case, some years had elapsed and no prospect appeared of an episcopal establishment In Canada, the court would then have declared the legacy void and distributed the fund to the parties entitled. So here, if it shall be found either at first that there can be no application of the fund in the manner directed by the will, or that the trustees, after making the attempt, fail in it, the court will then direct the same application to be made of it, which they would have done had that bequest been at first declared void. Where there exists a party entitled to receive a fund bequeathed for foreign charity, there can be no objection made to give over that fund to him and allowing him to administer it in the country in which the charity is to be established. This has been repeatedly done, both where a party was within the jurisdiction of the court and where he was beyond it, as Mornet versus Vulliamy, Switzerland, and Martin versus Paxton, Lyons, and Emery versus Hill, which followed the former precedents. The court has gone further of late years than Lord Hardwicke thought he could in Provost of Edinburgh versus Aubrey, for he then held that he could give no directions as to the distribution. But in Cadell versus Grant 1795, Oliphant versus Henry, and in Attorney General versus Lepin, the court interfered with the application of the fund, directing a scheme to carry the charity into execution. In the latter case, the objection was taken to the jurisdiction on the ground that the charity was to be executed in Scotland, but it was abandoned and the decree affirmed on the rehearing. In a subsequent stage of the same cause, the objection appears to have been renewed with effect. For there is a report of a rehearing of the former decree when Lord Eldon reversed so much of it as directed the scheme approved by the Master to be carried into execution. There is another case, the Attorney General versus the Mayor of London, as to a charity in America in which no difficulty was held to exist in directing a scheme as long as the American settlement remained under the crown, but then it was contended that the moment they became severed, the session at the end of the American War, the objection for the first time arose. The court appears there, nevertheless, to have directed a scheme, though it was said, and justly said, that exactly the same objection as to the jurisdiction existed to the scheme being directed before the severance as since. For the Court of Chancery had no jurisdiction before the severance to grant a scheme except to a party within its jurisdiction. The court operating through those parties, the severance made no difference in that respect. The difficulty in the present case arises from there being no party entitled to receive and administer the fund abroad to whom the Supreme Court in Bengal could hand it over, and no person within its jurisdiction who could administer the fund under its superintendence. But as in this country, the court has directed a scheme where there was a party, so it has also supplied the want of a trustee. In Attorney General versus Stephens, the charity was to be executed in Lisbon, and two trustees had been named by the testator, one of whom was an official person under an Act of Parliament, which being repealed, the co-trustee only remained. This was the Consul General, and he refused to continue in the trust without another to aid him. The Master of the Rolls appointed a new trustee on the Consul's application. Possibly this decision taken with the former one may afford a precedent sufficiently near to the present to warrant the course taken. But its complete jurisdiction must be sought in the peculiar circumstances of the case, and where there exists any possibility of pursuing the declared intention of the testator, upon the subject of which of all others he plainly was the most anxious, their lordships would be very unwilling to frustrate that intention by directing the funds to other objects. This seems to have been the strong inclination of the court below, and we only differ with them as to the means of giving effect to it. This, however, is not the peculiarity to which we principally refer. The objection in the ordinary case to administering a foreign charity under the superintendence of the court is this: those who are engaged in the actual execution of it are beyond the court's control, and those who are within the jurisdiction are answerable to the court for the acts of persons as to whom they can derive no aid from the court. Such an office will not easily be undertaken by anyone, and its duties cannot be satisfactorily performed. At least the party must rely more on the local, that is, the foreign authorities, for help than on the court to which he is accountable. But in the present case, there is reason to hope for the interference of the government. The court cannot shut its eyes to the weight which the government has with the court of Lucknow. It can hardly be said that the authorities there are wholly on the footing of a foreign and unconnected, though possibly they may be an independent state, and there seems sufficient ground for expecting that the Supreme Court may find fit persons possibly official persons willing to undertake the office of administering the charity under its superintendence. The jurisdiction of the court, moreover, extends over all British subjects residing within the limits of the Charter, whether in the British or native dominions, and this affords facilities for the execution of the charity under the court's superintendence, which could not exist in any of the cases cited. Section 4. The question on the Mortmain Act cannot be said any longer to exist in the cause. It is agreed on all hands that the statute does not apply to India. With respect to the application of the fund, should the execution of the bequest be found impossible, their lordships decline giving any directions because it might produce an impression that they doubt the possibility. Whereas, upon all the facts in the case and all that is known of the state of affairs in the East Indies, they entertain no doubt whatever respecting it. Section 5. The court below properly ordered the costs of all parties to be taxed as between solicitor and client and paid out of the general fund standing to the credit of the four causes. The costs and charges of the present appeal must be taxed in like manner as between solicitor and client and paid out of the fund standing to the general credit of the cause. The sum advanced being liable to apportionment among the funds when the cause goes back to the Supreme Court. In pursuance of the above judgment, the Judicial Committee presented their report to His Majesty in Council, setting forth the several points in which the decree in the court below ought to be reversed, and declaring with respect to the Lucknow Charity Court that the same should be reversed and that instead thereof it ought to have been and should be declared and decreed that if the whole sum of 2 lakh rupees, 2 lakh Sikka rupees bequeathed in the 33rd article of the said will of the testator, Claude Martin, for the finishing the house of Constantia, hath not been expended and applied for that purpose, whatever may remain thereof ought to be set apart from the funds now standing to the general credit of the said causes and carried to a separate account to be entitled the building and repairing fund for the house and establishment at Constantia, subject to the further direction of the Supreme Court and without prejudice to the final application of the same fund under the directions hereinafter contained or otherwise, and that the said Supreme Court should give all necessary directions for that purpose, and that out of the same funds standing to the general credit of the said causes, a further sum of 1 lakh Sikka rupees being the amount bequeathed in the 33rd article of the said will for the support of a college and school at Lucknow, together with accumulations of interest on the same from the death of the said testator until the setting apart of the same, be set apart and be carried to a separate account in the said causes, to be entitled Lucknow College and School Fund, subject to the further order of the Supreme Court and without prejudice to any question as to the final application of the same fund under the directions hereinafter contained or otherwise, and that out of the funds standing to the general credit of the said causes, the further sum of 3 lakhs of rupees or so much thereof as the said court shall find necessary be also set apart without prejudice to any question as to the final application of so much of the interest thereof under the said will applicable to the maintenance of the charitable establishment at Lucknow and subject to the further order of the court. But in the meantime, any monthly or periodical payments which shall have been directed by the Supreme Court to be paid out of such interest are to be continued. And their lordships do agree further, humbly do report that it should be referred to the master of said court to inquire and report to the said court whether it is in the power of the Governor General in Council at Fort William in Bengal to 8 trustees to be appointed by the said Supreme Court so as to enable them to give effect according to the said testator's will to the bequests respecting the charitable establishment and institution at Lucknow contained in the will of the testator and are thereby directed to be attached to the establishment of Constantia House or whether any other and what means through the medium of trustees exist for giving effect to such bequest. And that if it shall appear that by the aid of the said Governor General in Council or otherwise as aforesaid effect can be given to the said bequest, some proper persons be appointed by the said Supreme Court to be the trustees of the said charity to whom the interests of the funds applicable for the support of such charity should be from time to time paid to be by them applied and administered under the superintendence of the said Supreme Court in founding, establishing and keeping on foot the said charity, and that the Advocate General, the plaintiff in the first and the defendant in the third of the above mentioned causes should be at liberty to propose proper persons to be such trustees, and their lordships do agree further humbly to report that in all other respects the said decree should be affirmed. End of quote. On the 1st of March 1837, this report was taken into consideration by His Majesty in Council, and being allowed, it was ordered accordingly. Page 120. I think I should close the video here. It's nearly 2 hours. So roughly nearly 30 pages have been read. Okay, let me close.